Good day, my name is Dittke. I'm an attorney specialized in environmental and health and safety law. This training module covers the responsibilities and liabilities of management, and in particular senior management insofar as South African environmental, health and safety legal requirements are concerned. It will be shown that there is no uniform approach as to when precisely there is liability, specific legal requirements, as well as a level of fines and/or prison sentences when examining the various laws. Different environmental and health and safety laws will be highlighted, and so too general South African civil law principles governing damages. Considering that we are dealing with liability, and not only that of a company but also senior management, it must be stressed that this overview does not amount to the rendering of legal advice. Each case of potential liability must be analyzed on the basis of facts and the governing law. The main national SHE legislation for purposes of this overview is the following: Occupational Health and Safety Act, Compensation for Occupational Injuries and Diseases Act, National Environmental Management Act, Waste Act, National Water Act, Air Quality Act, various other regulations or notices in terms of these acts. These apply throughout the entire country. There are several other national environmental laws dealing with focused topics, for example biodiversity, protected areas, marine and coastal management. But for purposes of this training presentation, we concentrated on the main laws. On a municipal level, there are various SHE bylaws which differ from one local authority to another. Since there are 278 municipalities, it is impossible to include a review of their bylaws. In order to explain the legal principles involved, we created a fictional scenario. Our fictional company is Zodiac Chemicals, which manufactures and packages various chemicals. Due to breakdown of certain machinery, pressure built up in a pipeline causing it to rupture. A large spill occurred and approximately 2,000 liters of highly toxic chemicals found their way into a stormwater drain and soon thereafter a close-by river. Some of the spilled chemicals came into contact with hot machinery, and a large explosion and resultant fire were caused when the factory started burning. Unfortunately, the fire also damaged the chemical store, and large plumes of poisonous smoke were released until the fire was finally brought under control. Several Zodiac Chemicals employees, as well as some of a contractor who performed building work at the time, were badly injured by the explosion, while others had to be treated for inhaling poisonous fumes. A fair amount of the spill also flowed onto open, unlined ground. Before a specialized waste contractor was appointed to excavate and remove the contaminated soil, employees of Zodiac Chemicals already started with cleanup operations, but simply dumped the soil on the empty neighboring land. In order to examine the management liability and responsibility, let's jump straight to Section 16(1) of the Occupational Health and Safety Act. This act is actually outdated, and various reform proposals were proposed over the years. But for now, we must deal with it. Section 16(1) states that every Chief Executive Officer shall, as far as is reasonably practicable, ensure that the duties of the employer, as contemplated in this Act, are properly discharged. This clearly means that the CEO, MD or sole proprietor is responsible for health and safety compliance of the entity's activities. While Section 16(2) allows the CEO to assign duties to another person, this does not derogate the CEO's responsibility or liability in terms of the Act. Section 8 sets out the employer's, in other words, company's duties. In a nutshell, these are: provide and maintain a working environment that is safe and without risk to the health of employees. The provision and maintenance of systems of work, plant and machinery that are safe and without risks to health. Taking such steps or mitigate any hazard or potential hazard to the safety or health of employees before resorting to personal protective equipment. Making arrangements for ensuring the safety and absence of risks to health in connection with the production, processing, use, handling, storage or transport of articles or substances. performing a risk assessment of hazards to the health or safety of persons attached to any work which is performed. The same applies for any article or substance which is produced, processed, used, handled, stored, or transported, and any plant or machinery which is used. Establish what precautionary measures should be taken with respect to such work, article, substance, plant, or machinery in order to protect the health and safety of persons. This also requires providing the necessary means to apply such precautionary measures. Furnishing such information, instructions, training, and supervision to ensure the health and safety at work of employees. The company's duties are further to not permit any employee to do any work or to produce, process, use, handle, store, or transport any article or substance, or to operate any plant or machinery unless the necessary precautionary measures were taken. In other words, the company must take and enforce all necessary measures to ensure that the requirements of this Act are complied with by employees or third parties on site in the interests of health and safety. It must be ensured that work is performed and that plant or machinery is used under the general supervision of a person trained to understand the hazards associated with it and who has authority to ensure that precautionary measures taken by the employer are implemented. And lastly, the company warrants that employees do not commit any actions or omissions which would amount to an offense for the employer. Using the Zodiac Chemicals example, one would have to investigate whether the employer complied with the various requirements, such as ensuring that the workplace was safe, whether machinery is properly maintained and safe, if employees were properly trained, whether hazards were identified and assessed, etc. Section 9 stipulates duties of employers and self-employed persons towards third parties. In essence, this means that a company must ensure that third parties, like contractors or visitors, are not exposed to hazards. Conversely, self-employed persons, for example contractors, must conduct their undertakings in such a manner so as to ensure that their employees, as well as others, for example visitors to the site, are not affected. Here too, it would be necessary to determine if Zodiac Chemicals perhaps contravened their duty of care towards third parties. Employers having more than 20 employees must designate a health and safety representative. The number depends on the size and nature of the business. If taken seriously, the health and safety representative reduces the risk of liability of the employer in performing the following: review the effectiveness of health and safety measures, identify potential hazards and potential major incidents at the workplace, investigate complaints by any employee relating to that employee's health or safety at work. All this is extremely critical, as according to Section 13 of the Occupational Health and Safety Act, employers must inform every employee of hazards related to his or her work, as well as the precautionary measures which should be taken and observed. Employers further have the duty to inform the health and safety representatives beforehand of any inspections, investigations, and formal inquiries, and as soon as reasonably practical, of the occurrence of an incident in his or her workplace or section. It must be stressed that in terms of Section 37 of the Occupational Health and Safety Act, a company may be held liable for the acts or omissions of employees unless it is proved that the employee was acting with the connivance or permission of the company, it was not within any condition or scope of authority of the employee to do or omit to do an act, whether lawful or unlawful. All lawful steps were taken by the employer or user to prevent any act or omission. It would have been legally required of the company. In other words, if the company legally should or could have acted, the company is liable to conviction and sentencing. The fact that the company issued orders, for instance procedures or instructions, is only a limited defense of sufficient proof that all reasonable steps were taken. This also applies to third parties, for example contractors, as they are deemed to be the company's employees unless the contractor has signed an agreement which sets out various compliance duties in terms of the Occupational Health and Safety Act as well as the other numerous regulations and requirements. In practice, this is called a Section 37(2) agreement, also known as a mandatory agreement, which every company should have in place. If not, the company exposes itself to potentially serious legal as well as financial risk. Ideally, the agreement should also cover environmental duties, since further potential liability exists in terms of environmental legislation, as will be shown later on. Section 37 further imposes personal criminal liability on employees where they commit or omit an act which would be an offense for the employer. In other words, personal criminal liability is imposed on the employee for something which the employer should have done. Any person convicted under the Act is liable to fine up to 50,000 Rand or imprisonment of up to 1 year or both. This includes ordinary employees and senior management. The Act, in Section 38(2), further deals with instances where any person would or could have died on the basis of culpable homicide, in other words negligent death and not murder, in the event of an incident. It is essential to know that whether or not the person died is irrelevant. Only the fact that the person might theoretically have been killed is important. An example would be if there was an explosion which could have killed employees or third parties but fortunately did not do so. In such case, the employer is potentially liable to a fine of 100,000 Rand or to imprisonment up to 2 years for culpable homicide or both. Going back to our example, it is clear that Zodiac Chemicals could face prosecution in terms of Section 38(2), as the explosion and resultant toxic fumes could have killed several people. In the event of a person dying, becoming unconscious, or losing a limb, a labour inspector must be notified immediately. The same applies if a person becoming so ill that he or she is likely to die or suffer a permanent physical disability or being unable to work for at least 14 days. The site then may not be disturbed and no article or substance may be removed unless an inspector permits this. The employer must also within 7 days report to an inspector if a major incident occurred. This is also required if the health or safety of any person was endangered, especially when a dangerous substance was spilled, the uncontrolled release of any substance under pressure took place, machinery or any part thereof fractured or failed, resulting in flying, falling or uncontrolled moving objects, or machinery ran out of control. When it comes to occupational accidents and diseases, the Compensation for Occupational Injuries and Diseases Act becomes relevant. Employers must register with the Compensation Commissioner and keep a record of the earnings and other prescribed particulars of all employees. The returns of earnings must be furnished to the Commissioner by 31 March of each year. Annual contributions are also payable by employers to the Director General of the department. Within 7 days of learning of an employee's accident, it is the duty of the employer to report it to the Commissioner. Compensation claims must be submitted within 12 months to the Commissioner or the mutual association concerned. If this is not done, the claim will prescribe. Schedule 3 of the Act sets out numerous occupational diseases. These must be reported by the employer within 14 days of having become aware of it. This is irrespective of whether or not the employer is disputing that the disease was caused through work. Compensation payable is regulated by the Act. A claim for a higher amount can, however, be submitted by an employee if the accident or occupational disease was due to the negligence of the employer or an employee managing or controlling the business or any of its branches or departments, or an engineer appointed to be in general charge of machinery, or of a person appointed to assist such engineer, or a person appointed to be in charge of machinery. Any person convicted of an offence in terms of the Compensation for Occupational Injuries and Diseases Act is liable to an unspecified fine or imprisonment of up to 1 year. Since in our fictional Zodiac Chemicals example, several people were injured, they would be entitled to compensation. Should some of them perhaps contract an illness in due course because they inhaled the toxic fumes, They would also be entitled to compensation in this regard. Next to the fines and sentences under the Compensation for Occupational Injuries and Diseases Act, there might be prosecution under the Occupational Health and Safety Act. Any person convicted in terms of this act is liable to a fine up to 50,000 Rand or imprisonment of up to 1 year or both. Furthermore, there are many regulations under the Occupational Health and Safety Act, and each of these imposes its own level of fines or sentences. These regulations are Hazardous Chemical Substances Regulations, General Safety Regulations, General Administrative Regulations, Driven Machinery Regulations, Pressure Equipment Regulations, General Machinery Regulations, Noise-Induced Hearing Loss Regulations, Electrical Machinery Regulations, Hazardous Biological Agents Regulations, Major Hazard Installation Regulations, Electrical Installation Regulations, Asbestos Abatement Regulations, Construction Regulations, Facilities Regulations, Environmental Regulations for Workplaces, Ergonomic Regulations, Explosives Regulations, Lead Regulations, Lift, Escalator and Passenger Conveyor Regulations, and for the sake of completeness, even if not relevant here, the Diving Regulations. Using our fictional scenario, Zodiac Chemicals once more, it would be at least 5 of these regulations which may have been contravened. Hazardous Chemical Substances Regulations, General Safety Regulations, Pressure Equipment Regulations, General Machinery Regulations, Environmental Regulations for Workplaces. National Environmental Management Act. This act is a framework law for all environmental matters and is therefore relevant for any company. Section 28 imposes a duty of care and states that every person who causes, has caused, or may cause significant pollution or degradation of the environment must take reasonable measures to prevent this from occurring, continuing, or recurring. Where such pollution or degradation is authorized by law, for instance a license, or cannot reasonably be avoided or stopped, it must be minimized and rectified. This is also relevant where the pollution or degradation occurred before the commencement of this Act, November 1998, arises or is likely to arise at a different time from the actual activity that caused the contamination, in other words, in future, or arises through an act or activity of a person that results in a change to pre-existing contamination. The duty applies among others to an owner of land or premises, a person in control of land or premises, or a person with the right to use the land or premises. Measures that must be implemented include investigating, assessing and evaluating the impact, informing and educating employees about the environmental risks of their work and the manner in which their tasks must be performed in order to avoid causing significant pollution or degradation. Ceasing, modifying or controlling any act, activity or process causing the pollution. Containing any or preventing the movement of pollutants or the causant of degradation. Eliminating any source of the pollution or degradation, or remedying the effect of the pollution or degradation. Should no action be taken, the authorities can intervene and perform the required measures. In that case, they are entitled to recover their costs, and the following may be held liable. Any person responsible for or who directly or indirectly contributed to the pollution or degradation. The owner of the land at that time, the owner's successor in title, in other words the new owner, the person in control of the land, any person with the right to use the land at the time, any person who negligently failed to prevent the activity or process, or alternatively the situation from coming about. These costs include labor, administrative and overhead costs. Section 34 of the National Environmental Management Act deals with criminal proceedings. I am often asked if employees can sue their employer. While Section 8 of the Occupational Health and Safety Act imposes various duties on an employer in respect of their employees and for which employers may be criminally prosecuted if breached, employees cannot sue their employer for compensation for injuries or diseases. Section 35(1) of the Compensation for Occupational Injuries and Diseases Act excludes such claims. However, where the injury or disease was caused by a third party, for example a contractor, working on the site of the employer, the employee can sue the third party for damages. For any other damages, for instance damage to property or monetary benefits, for example commission, employees can sue the employer since this falls outside the scope of the Compensation for Occupational Injuries and Diseases Act. National Environmental Management Act. This act is a framework law for all environmental matters and is therefore relevant for any company. Section 28 imposes a duty of care and states that every person who causes, has caused, or may cause significant pollution or degradation of the environment must take reasonable measures to prevent this from occurring, continuing, or recurring. Where such pollution or degradation is authorized by law, for instance a license, or cannot reasonably be avoided or stopped, it must be minimized and rectified. This is also relevant where the pollution or degradation occurred before the commencement of this Act, November 1998, arises or is likely to arise at a different time from the actual activity that caused the contamination, in other words, in future, or arises through an act or activity of a person that results in a change to pre-existing contamination. The duty applies among others to an owner of land or premises, a person in control of land or premises, or a person with the right to use the land or premises. Measures that must be implemented include investigating, assessing and evaluating the impact, informing and educating employees about the environmental risks of their work and the manner in which their tasks must be performed in order to avoid causing significant pollution or degradation. Ceasing, modifying or controlling any act, activity or process causing the pollution. Containing any or preventing the movement of pollutants or the causant of degradation. Eliminating any source of the pollution or degradation, or remedying the effect of the pollution or degradation. Should no action be taken, the authorities can intervene and perform the required measures. In that case, they are entitled to recover their costs, and the following may be held liable. Any person responsible for or who directly or indirectly contributed to the pollution or degradation. The owner of the land at that time, the owner's successor in title, in other words the new owner, the person in control of the land, any person with the right to use the land at the time, any person who negligently failed to prevent the activity or process, or alternatively the situation from coming about. These costs include labor, administrative and overhead costs. Section 34 of the National Environmental Management Act deals with criminal proceedings. As part of the criminal proceedings, a court may establish whether the offence caused loss or damage to any organ of state or another person. Once the loss or damage was established, the court can give judgment for this amount and it becomes a civil judgment, meaning that the state or other person can, for instance, have a warrant of execution issued. Where an employer failed to take all reasonable steps to prevent any unlawful act or omission committed by a manager, agent or employee, the employer may be held liable. This includes liability not only for a fine, but also the additional damages or remediation measures. Conversely, the manager, agent or employee can be held liable for an act or omission of the employer. A director can be held personally guilty. Upon conviction, either a fine or prison sentence, including an order for additional damages or remediation measures, may be imposed. This is, however, only if the director failed to take all reasonable steps that were necessary under the circumstances to prevent the commission of the offence. The director has the onus to prove that he or she is not guilty. A director is defined as a member of a board, executive committee, or other managing body of a corporate body, close corporation, or partnership. Schedule 3 of the Act refers to various other environmental acts, so-called specific environmental management acts, for Waste Act, Air Quality Act, National Water Act, etc. This means that if a person is convicted for contravening any of the Schedule 3 laws and/or the National Environmental Management Act, the provisions of Section 34 are applicable. For the National Water Act, this means wherever another person suffered harm or loss because of the offence or damage was caused to a water resource, the court can, upon request from the aggrieved party, inquire into the extent of the loss or damage and order the following: damages award, payment by the accused for the costs of remedial measures implemented, implementation of the remedial measures. Contraventions of the Act may result in criminal prosecution. If convicted, an unspecified fine or imprisonment of up to 5 years or both can be imposed. For second or subsequent convictions, an unspecified fine or imprisonment of up to 10 years or both is possible. The criminal prosecution under the Air Quality Act also depends on how serious the contravention is, if it was intentional, and how large the potential environmental impact is or may be. If convicted, a fine of up to 5 million rand or imprisonment of up to 5 years or both can be imposed. For second or subsequent convictions, a fine of up to 10 million rand or imprisonment of up to 10 years or both may be given. There are numerous regulations and other subsidiary laws in terms of the Act. Similar fines and sentences may be imposed for transgressing them. Finally, contravention against the Waste Act may result in quite a harsh fine and/or prison sentence. A fine up to 10 million rand or prison sentence of 10 years or both may be imposed by the court. This is especially for contraventions dealing with general duties in respect of waste management that were not complied with, not being in possession of a waste management license, disposing of waste in an authorized manner, for example dumping, not reducing, reusing, recycling or recovering waste when there is a legal duty to do so. Where an emergency incident is triggered by waste, for instance a spill, a fine up to 5 million rand or prison sentence of 5 years may be imposed. The same applies if no waste management plan was drawn up and submitted to the minister. If a person is convicted by a court but nonetheless continues with the offence, a fine of 1,000 rand or prison sentence of 20 days or both may be imposed for each day the offence carries on. Following the National Environmental Management Act, an accident like our example of Zodiac Chemicals must be immediately reported, contained, and cleanup operations undertaken. Should this not be done, the authorities can step in. Seeing that a significant degree of air pollution was caused by the explosion, Zodiac Chemicals could potentially face an additional harsh fine and/or sentence under the Air Quality Act. Zodiac Chemicals also contravened several requirements of the Waste Act, such as illegally dumping the contaminated soil. In addition to that, the municipality could also institute legal action, since bylaws dealing with waste, stormwater, air quality, health, environmental health, fire safety, and potentially water supply were contravened. Zodiac Chemicals might also deal with additional criminal liability under the Criminal Procedure Act. Section 332(1) of this Act deals with corporate criminal liability and, in a nutshell, states that a company can be held liable for any act or omission that is regarded as a crime, irrespective of whether it is classified as such by legislation or the common law. This means that a company can be convicted of criminal charges. This is essentially the same position as in the laws discussed. And lastly, Zodiac Chemicals might face civil liability. Civil liability deals with claims between individuals and/or companies. An aggrieved party therefore has several options and can lay criminal charges, institute a civil action for compensation for harm, damages or loss suffered, and/or apply for an interdict. Let's assume some of the chemicals were also spilled onto this aggrieved neighbor's land, and Zodiac Chemicals did not clean this up soon enough, and the soil has therefore become polluted. The neighbor decides to have the soil excavated and removed. Damages were therefore suffered in the form of cleaning up and rehabilitating the land. In order to claim damages, the neighbor will firstly have to prove that Zodiac Chemicals caused the spill and that the company could or should have prevented it. In addition, the neighbor will have to prove the amount of damages suffered. If successful with both, damages will be awarded to the neighbor. A damages claim is often instituted against the company as well as specific employees. This is in order to establish either intent or negligence on behalf of employees. Companies are, moreover, bound by the principle of vicarious liability, which means that they are liable for acts or omissions of their employees. In closing, the current South African position for personal criminal liability of employees is that employees will only be held liable for companies' actions if they somehow participated in the offense or alternatively failed to take steps to prevent it. Therefore, in practice when dealing with liability, the authorities usually opt to take legal action in terms of environmental, health and safety legislation, as this provides far more liability, not only that of a company, but also personal liability of senior management. Thank you for being proactive and watching this video.